Good afternoon. Welcome to this webinar on GDPR. My name is Kishore Vaswani, and I'm the CEO of ControlCase. Thank you for attending this webinar on GDPR presented by ControlCase. A few housekeeping items before we get started. As we go through our webinar, please feel free to type questions in the questions window, and we will answer them after the webinar is over. We expect the webinar to run anywhere from 20 to 25 minutes. The purpose of this webinar really is to be very focused at a high level on GDPR. ControlCase is publishing a whole range of thought leadership material in the coming weeks on GDPR and CCPA, which is the California Act, both of which touch security and privacy issues. So please feel free to contact me or anyone in ControlCase. Certainly feel free to go through our website at www.controlcase.com to set up 30 minutes to have us walk you through the data we have found on GDPR and CCPA as it relates to both security and privacy in a one-to-one call with me and other folks at ControlCase. Again, today's session is going to be very high level. We expect the session to run between 20 and 25 minutes. And please feel free to type questions in the questions window as we go through the webinar today. Also, if you have not attended already, please feel free to go and view any of our other webinars on www.controlcase.com, as well as sign up for future webinars that we may have. Thank you once again for attending, and we'll get started here. Our agenda for the day is going to be to talk a little bit about GDPR at a high level, talking about the non-compliance consequences. What do you as a company have to do to be GDPR compliant? We'll talk a little bit about the technical articles. We'll talk a little bit about a tactical compliance methodology from a security perspective, but we'll also touch briefly on some privacy breach notifications and rights management issues. We will revisit the ControlCase Solution, and then as you guys are typing questions in the questions window, we will certainly make sure that we answer them in the order that we receive them. Certainly feel free to put questions in context of GDPR or any other regulation that spans across security and privacy, in this webinar. So the first one is, what is GDPR? So this was adopted in 2016 and went into effect in 2018. And at the highest level, GDPR talks about protection of European Union citizen data. It spans across security, privacy, and many other aspects. We will talk about some of the terminology here in a second, but it also talks about how the consumer, the EU consumer or the European Union consumer, must be worked with in that it comes to things like consent, data protection, erasure of data, and what can and cannot be done. As you navigate through GDPR, there are various terminology that you will probably hear in the general context of GDPR. A data processor and a data controller. A data processor is basically someone who would process data on behalf of the controller. It could be a vendor. Sometimes both entities could be one and the same entity as well. But again, the data controller is who is the authority on that personal data, and then the processor means who is processing on behalf of the controller. Regulation versus directive. Simply put, regulation is mandatory, directive is a nice to have. GDPR is a regulation and mandatory. And the DPA, or the Data Protection Authority, are the agencies that are responsible for managing and enforcing GDPR. So now the question comes down to, what are the consequences if someone is non-compliant? Well, certainly the courts and judicial remedies, one. Certainly complaints with the authorities is the other. But non-compliance consequences could hit as much as 4% of a company's annual revenue. So as you can see, fairly significant consequences of non-compliance. So now, we talked about what is GDPR. We talked about what are the consequences of not complying with GDPR. Let's now talk about what is required to be compliant with GDPR. Number one is a data impact assessment. The data impact assessment basically ensures that all the elements of GDPR are being looked at by the organization from an end-to-end data flow perspective. This spans across security and privacy. And this must be done not only as a one-time activity. The regulation required that it be done before it went into effect in 2018. But for companies, on an ongoing basis, they need to be doing this as there are changes to systems or processing mechanisms, because obviously the impact of data changes if you get a new vendor, if there is a mergers and acquisition, if you implement a new system, and 100 different things can result in changes which require that the data impact assessment be done on an ongoing basis, at least annually is recommended. The second thing that is absolutely required is a data protection officer. So every entity needs to have a data protection officer. It could be an employee, it could be outsourced. Multiple entities can combine to have a single DPO. The data protection officer must be independent outside the IT and the operating chain, and they need to ensure that they monitor compliance to GDPR, as well as they are coordinating with the Data Protection Authority on an ongoing basis to answer any questions that come up, any complaints that happen, or any of those aspects that have to be dealt with in the context of GDPR. All right, so we talked about what is GDPR. We talked about the fact that GDPR spans across security and privacy. And then we talked about some of the high-level areas that, from a privacy perspective, such as consent, right to be forgotten, and so forth, that need to be there. We talked about the fact that both a data impact assessment and assignment of a data protection officer is mandatory for compliance to GDPR. So let's switch gears and talk about what are some of the key articles within GDPR. And again, this is just a very high level table. We have done extensive research and are going to be publishing extensive data on, by country data on various of these aspects when it comes to both GDPR as well as CCPA. So again, feel free to reach out to us if you want us to walk you through the early versions of that data. We would love to get your feedback on that data as well. But the key articles of GDPR at a high level, we certainly will distribute these slides, so I won't go through each one, but they essentially span across what are the rights of an individual, including consent, how can the data be processed, everything around the EU citizen. Number two, they talk about security of data. Number three, it talks about who are the other parties that are involved. For example, certification bodies, supervisory authorities, and so forth. And then finally, it really talks about, at the end of the day, if someone is not compliant, what are the remedies, liabilities, and penalties when it comes to GDPR. From a tactical perspective, when you're looking at GDPR, think of it broadly in the category of security, rights management, privacy, and breach notification management. And ControlCase has partnered with a partner to provide a holistic solution beyond just security. Experts on rights management, privacy, and breach notification management is fairly significant from a legal perspective and a country perspective. And so we, along with our partners, are providing a comprehensive security and privacy solution for addressing the tactical steps for GDPR. And again, from a security perspective, we're going to go through in some details. From a privacy perspective and a rights management perspective, we're going to keep it at a high level. And then certainly reach out to us if you want any more information on that data or questions. Here are some of the tactical aspects of security. One is asset and vulnerability management, ensuring that the systems that are handling data are being appropriately managed from a vulnerability management and a patch management perspective. Data management. Everything in GDPR is about data. And so knowing where the data lies, classifying it, encrypting it, monitoring it, and so on is an important aspect of GDPR security. Logical access, as it goes with any of the common regulations out there, ensuring strong logical access is important. So is ensuring that you have strong physical security, and that is an important part of that. Risk management, which is ensuring you're doing at least annual risk management efforts. A lot of times these risk management efforts can be combined with the data impact assessment, and we have seen a lot of our customers actually combine the annual risk assessment to the data impact assessment that they're doing to really have a comprehensive report that includes both aspects of it. Policy management, everything needs to be documented and appropriately updated on an ongoing basis. Also training and communication of that to everybody is an important part of this. We talked about data processor and data controller. And so very much in that context is vendor and third-party management, ensuring, at the end of the day, when you are outsourcing data to third parties, you can outsource data, but you cannot outsource the liability that comes from GDPR. And so ensuring you have a strong third-party management program and the appropriate legal contract is an important part of managing GDPR. We talked about breach notification, and hence incident management becomes an important part of from a security perspective as well. So we went and talked about in some detail about some of the high-level programs you would need to have as part of your adherence to GDPR from a security perspective. We will touch at a very high level over the other three aspects, and certainly we won't get into that level of detail, but certainly feel free to reach out to us, and we are happy to connect you and us on the same call with our partner to go through both the security as well as the privacy aspects. So one is rights management. That really talks about what are the rights that consumers have. What are the rights that a consumer should have from both the data controller and the data processor? And it includes things like right to ask for modification of data, right to ask for deletion of data, right to ensure that the right consent must be received before a processor can actually do something. It also requires that a processor, has its responsibilities in cases of breach notifications, and the processor needs to provide disclosures and a good tabulation of how the disclosures were done. Next, so we talked about, security. We talked about rights management and what are the different rights of consumers. Next, let's get into privacy management. And privacy management really requires requests and ensures that where the data is either disclosed or used for a EU consumer is tightly managed. It includes things like rights to be forgotten. It ensures that both the processors and the controllers should have appropriate safeguards to protect the privacy. It sets limits on what can be done. And for third parties, again, it requires breach notification and accounting of disclosures. So we talked about, broadly speaking, security, rights management, privacy, and the last piece we'll talk about is breach notification management. As we look at this last piece, this really is what needs to be done once a negative event has happened, right? And no company wants to be in a position that they have to do this for the first time after a breach has happened. And so certainly it is important to have an incident response program and breach notification management as part of that. And this includes things like, number one, what is the mechanism of breach notification? Whom will you notify? How soon? What are the volume thresholds? How will you interact with your ecosystem of third parties? So how do you notify is an important piece. And then what you notify is also an important piece, which is content of breach notification. So ensuring that this is handled as part of your incident management program is extremely important. It should include what is the mechanism, what is the flow chart, and what are you going to disclose, how, with, and what's going to be the content. A couple of things as we reach the end of our webinar. Again, feel free to put questions in the questions window on this topic or any other IT compliance topic, and I will be sure to answer them in the order we receive them. And so from a control case perspective, we perform a data impact assessment for our customers at a very detailed level from a security perspective and at a little high level from a privacy perspective and a rights management perspective. We now have, as I said, we have partnered with another firm, and we are now able to provide a detailed privacy and rights management engagement that includes the security aspects. And so certainly the data impact assessment is something ControlCase can provide from an holistic perspective. Number two, data discovery. We have software that can be used to identify sensitive data, including EU citizen data within databases and environments. Certainly, we are also an assessor and are able to certify companies to multiple regulations, such as HITRUST, PCI, DSS, ISO 27001, and so forth. So certainly, feel free to reach out to us for any of these certifications through our website or through your ControlCase representative. Thank you. That was all we had on the webinar. Now I will answer the questions that have been put in the Q&A window and in the order that we received them. The first question is that both data controllers and data processors must maintain a record of categories of processing activities. Is there a GDPR approved list of categories of processing activities that you can direct me to? Thank you for that question. And that is correct. Both, both data controllers and data processors must maintain the records. Generally speaking, if there is anything that touches EU citizen data, either from a actual data perspective or anything that controls the data perspective, it could be things like security items. Those are the things that must be looked at as part of the GDPR assessment. And records and categories of processing of that must be maintained. We can certainly if you can just reach out to us, we can certainly send you some sample categories of processes. But certainly the full list of processes depends on the the business you're in, and so it'll change from time to time. But feel free to reach out to us either on our website or through a representative, and we can send you a representative set of activities as well as formats that can be used for maintaining what processing activities. The next question is, can consent include no right to be forgotten? I think this is a question that one of our legal partners would be able to answer better, and we are happy to get it to you. My understanding, which is not legal understanding, but my understanding is, consent can include many things, but a consumer always has the right to be forgotten. So a consumer can have given something in the past, but everyone has to provide a consumer a method to to exercise their right to be forgotten. And so I think that is a basic right that exists within GDPR. The next question is, what if I have a process like a shopping cart and I need information for 7 years for authorities? And the question, I guess the question really comes in the context of overall, if you have no right to be forgotten, how can you store data, from an overall legislative perspective? And that's again another great question. The right to be forgotten basically makes sure that someone is not being used for any futuristic activity, right? And it goes beyond just technology. It goes into the processes. It should be emulating an environment as good as we know nothing about the customer. Now, for record keeping, right, which happens all the time, and there are many regulations out there, absolutely, you have to comply with the local laws and have an ability to provide to the local laws any history that they require from an overall perspective. And so, while technically, so the right to be forgotten can be kept, do not read into that as a completely technical removal. It could mean a virtual removal, such that the company and the organization does not know about it, while ensuring that if it's required in a future, requirement, there might be areas that you would have to provide. Now, again, that depends on the requirement. If you are looking at Treasury, that might be one requirement. If you're looking at, some other organization, there might be different requirements. But all that needs to be done as part of your planning and your data impact assessment. The next question is, outside EU citizens, are there, any impact in placing technology in different countries like Ireland and Germany, I believe, is the question. And nothing in GDPR should prevent having infrastructure at different places. However, it is important that you look at the data flow from an end-to-end perspective and see who accesses that data and how the local country laws will relate to disclosure of that data. So there's no hard and fast rule that says a server cannot be placed outside a country of origin, but there's certainly many things you want to look at from you want to make sure you're looking at before, as you make that decision, and it should not be just based on physical aspects. It can be on many other logical aspects as well. The next question is around, do I have to delete public IPs, and how do I know if an EU person has public IP? Again, a much more detailed question. The general answer is, if it cannot be tied back to an individual, you should be able to keep it. But of course, for any forensics investigation, you should be able to recreate the data. we have time for a couple of more questions that, which I will certainly answer. But if we are not able to answer all your questions, certainly feel free to reach out to us. The next question is, can the solution be integrated with vulnerability assessment? And really, when you're talking about vulnerability assessment, you're looking at, first of all, one aspect of it, which is the information security aspect. And so when you're looking at GDPR, you're looking at, number one, what are the four aspects? One of which is security, then there's rights to be forgotten, rights management, privacy, and breach notification. And then within the security aspects, you could integrate vulnerability management with your GDPR processes. The next question is, how can a consumer know if I deleted them? So there's that was the part of notifications that I referred to earlier, which is there needs to be a process for them to formally ask you that evidence, and you need to, in the right manner, confirm to them that their right has been exercised. Again, there will be a mapping between what you do technically and what you tell the customer, which might not necessarily be a one-on-one, but just like you said, it doesn't mean that you have to look for it does not mean, to your other question, that you have to look for a customer in your backups and delete them. It does not mean that. You don't have to delete them physically. You just want to make sure you're not using them for any processing activities. The next question is, I see there are many compliance certifications that are such as PCI, HIPAA, High Trust. How do we know which compliance regulation we need to have? So as a service provider, there are two questions you should be asking as you get into any compliance or certification regime. First of all, what are the compliance or certifications that my customers are asking me, right? So that in order to continue doing good business with my customers, I need to be compliant to that. Number two is, which industry am I in? So which compliance regime will help me be more secure, in line with the laws, and keep me basically secure, compliant, and in line with the laws in the areas where I'm doing business. So number one is industry specific. Number two is your customer specific, which should help you determine how and which regulations you comply with. And just like we do at ControlCase, many times you can do a single assessment and comply to multiple laws and regulations. That was all the time we had, and that was, I believe, most of the questions, but I know there are a few others that we would certainly be able to answer as well. Again, feel free to reach out to us in case of any questions. We will ensure to keep on providing more details on this and future webinars. Please go to our website. And again, please feel free to go through our website, through our GDPR compliance page, and request us or your representative if you want to set up 30 minutes to have us walk you through all the data we have gathered at a very detailed level on GDPR and CCPA. We can typically do it over a 30-minute call and then certainly email you the report after that as well. Thank you, everybody, for your time, and have a good rest of the day.